I don't report to Paul Mashatile. The words of Public Works Minister Dean McPherson hitting back at the Deputy President after he suggested that McPherson either implements government policy or must resign. It all comes after President Ramaphosa signed the Expropriation Act into law last week. It's legislation that now allows the minister responsible for public works and infrastructure to expropriate property for a public purpose or in the public interest. Dean McPherson says it will not happen under his watch. His boss, DA leader John Steenhuisen, has written to President Ramaphosa to express his party's dissatisfaction. But once an act of parliament has been passed, the president may not simply veto it or refuse to sign it into law. Can he? Have a listen to DA leader John Steenhuisen speaking in Cape Town this weekend.
Thank you for the question, Paul. Let me be very clear. This isn't an ultimatum. It is a mature call as a partner in the government of national unity for a reset in the relations where we are respected and treated as partners in this government of national unity and not as spectators. And it doesn't matter whether it's foreign policy, it doesn't matter whether it's government policy, and it shouldn't matter if it's regulations. This administration is not a continuation of the Sixth Administration. The Sixth Administration was an administration led by an ANC majority government. This administration is now part of a government of national unity. And therefore to expect us as a new administration to come to simply slipstream into everything that the Sixth Administration did is fanciful and is simply not based in the realities of how government changes work.
All right, I'm pleased to tell you we've got on the line to explain all of this to us, Lecturer of Property Law at Stellenbosch University, Tanveer Jeewal, who joins us now on the line. A pleasure to have you on the show. Welcome to 702 Breakfast.
Thank you so much for having me.
All right, I played you that clip there where the DA leader is arguing about which laws were made by which administration. Does it miss the point? An act of parliament, once passed, has to be signed into law after the president has applied his mind, or am I wrong?
No, you're absolutely right, and he absolutely misses the point. So the issue is that if the president wanted not to sign it, he did have the option, but it wouldn't be to consult with members of the DA or any other members of parliament. Instead, he would have to ask his legal consultant and send it back to the Constitutional Court and ask the court whether that bill is constitutional. It is only then, once the court has said that it is not constitutional, that the president could refuse to sign it. The president, as you mentioned, cannot simply veto a bill of parliament that has been passed already. He has to sign it and assent to it, and now it's simply law. It has nothing to do with it being of a previous administration. This bill has gone through parliament and has been there for 5 years. They've had plenty of opportunity to debate it, and they've done so and clearly have lost, and now the bill is law.
Could the DA simply not have gone to court to take this legislation under review?
So it had to wait for it to be passed into law and then take it under review. At that stage, only the president could have sent it. You know, when it has been assented already, it was only, it had been passed by parliament, only the president could send it to the Constitutional Court and ask for its opinion. But now that's exactly what the DA is going to do, which is the correct process of the law. The DA cannot simply say that the president could have refused to sign it.
They've raised the issue of the statement of intent that they signed with the ANC to form this grand coalition. But surely the document that guides how South Africa works is, in fact, the Constitution.
Absolutely. So the Constitution obviously guides how South Africa works, but also I want you to remember that this bill had actually been sent for assent, and what that means is it had been sent to the president back on the 19th of March 2024, right? So we're talking about a year ago, before the GNU, right? So obviously already then the fate of the bill had been sealed. So the president could either send it to the Constitutional Court or he could sign it, right. But the intent hadn't been signed yet. So it has nothing to do with the GNU.
So where does this place the current minister then of Public Works, Dean McPherson? I mean, can he simply say not under my watch?
No, absolutely not. I mean, unfortunately for him, what President Ramaphosa had said is true. The minister has to implement the law that has been procedurally and soundly passed, Or if he refuses to implement the law, in which case he's taken an oath to do so, right? He has to resign because he's refusing to do his job as a minister.
So
as a minister, I just wanted to quickly add, as
Sure.
a minister, he's there to represent the whole of South Africa, not just the DA policies, right? It's important to remember that.
Just explain the process in terms of the actual things that must be done, the T's and C's, if you will. Must the minister co-sign this law?
No. So actually, the minister takes the decision to expropriate, right? So the minister is the one who has to essentially identify the land and decide to expropriate. So in practice, if you have a minister who has explicitly said that he refuses to even identify any land under this act, then for all intents and purposes, he's refusing to do his job. In actuality, what should happen is you should have a minister who has taken the oath and is willing to do his job as he's supposed to, and he goes ahead under this mandate and identifies land in the public interest that needs to be expropriated and goes ahead. Otherwise, what's the point of having an act if the minister simply refuses to implement it? It's simply undemocratic.
All right, let's talk now about what this new law does and doesn't do. I noted today one of the writers in one of the newspapers says this has now dealt a body blow to our economic prospects. Let's talk about the protection of property rights as guaranteed under the Constitution. How does this new law square with that?
So obviously under Section 25, you have property rights that are guaranteed to a certain extent. It's important to remember that it is limited under the Constitution. So this would just be an instance of its limitation. Expropriation is nothing new in South African law. It dates back to the Union. It dates back to apartheid. It's always been here. The issue that people are having is with regard to the amount of the compensation, right? We're looking at just and equitable for nil compensation. We need to remember that there's a lot of discretion there. Right? The court is going to look at it on a case-by-case basis. What I mean by that is every case is going to be dependent on the facts. And also, if you actually read the act, you see that there are very minor circumstances under which the land can be expropriated for nil compensation. And these circumstances are very obvious. If someone has abandoned the land, and what I mean by that hasn't paid the rates for ages, right? Then in those cases, for example, the state can expropriate without giving compensation. It would be seen as just and equitable if the court finds it to be so. Now, we need to ask ourselves whether it was a thriving economy that would allow people to not pay rates for years and years on end with no consequences whatsoever, right? Property ownership comes with responsibilities as well. This is just one of the consequences of not exercising the responsibility of not paying your rates, for example.
The MKP and EFF, on the other hand, feel this law has not gone far enough. Are they right to say that the changes are merely cosmetic?
Well, I have to be honest and admit that it's a very symbolic law more than anything else, right? It's a very procedural act. And what that essentially means is that basically the law has been in place already for the state to be able to expropriate land, at least under market value and for land reform. But so far, the state has barely done so. And when it has most of the time offered more than the market value, right? So the landowner would sell the land and get less price than what the state was offering when it's expropriating the land. So if the state has been unwilling to do so under law that already exists, it's very doubtful that it will do so now under this new law. So many of us do think that it's mostly symbolic and a lot of posturing in terms of this law. It's caused a lot of debate, but I'm very doubtful that we will actually see any meaningful progress under transformation.
I mean, how will it actually work? Because it talks about public interest, which it says includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources in order to redress the results of past racial discriminatory laws or practices. That sounds like they mean business.
Yeah, so in practice, what would actually happen is the minister would identify a plot of land, for example, like I mentioned, has been abandoned, hasn't been catered to for 20 years. They cannot identify the owner maybe, or maybe they can, but the owner hasn't paid rates for ages. There's proof that it's been abandoned. Once the state identifies it, it tries to contact the owner to let them know that it will expropriate the land for maybe land reform purposes, which possibly could include housing, or possibly could include actually giving it to a group, a community of people. And based on that, what will happen is if the owner was there, they could actually contest the expropriation. But if the owner fails to contest anything, then we move to the compensation part of the business.
It also talks about how the power to expropriate may not be exercised unless the expropriating authority has without success tried to reach an agreement with the owner or holder of a right in property for the acquisition thereof on reasonable terms. I mean, you can't really say no, can you?
So in essence, you could say no. There are moments where you could. This is the whole deal with this specific line, is that they will try to come to a sale agreement with you, ideally, so that maybe you can negotiate the terms of the sale. And if you refuse to sell the property, then we move to expropriation. But we need to remember, expropriation is very technical. There's like 18 steps. And during a lot of those steps, you are able to counter, right, this expropriation claim. You are able to go to court and refuse that the land be expropriated, but you would have to obviously provide reasons why this would happen. But again, I just want to highlight that no one's home is likely to fall under the circumstances for nil compensation. We're talking about land that's been abandoned or land that's causing a health and safety risk to people, which is doubtful that a home would actually mean that.
So ultimately, is this mere saber rattling just to calm the DA's base?
Yeah, unfortunately, I would think it might be.
All right, appreciate your time and thank you for your perspective. Tanveer Jeewal is a lecturer of property law at Stellenbosch University.
Current events, developing stories,
tough questions,
your voice making a difference.
This is Breakfast with Bongani Bingwa.